Hey everybody, it's Christopher Small with CMS Law Firm. We do estate planning, we do probate, we do it well. And today, I want to talk to you about making handwritten changes on your will. Before we get to that, though, I want to remind you, if you have questions about estate planning or probate, and you want to talk to somebody about it, you can talk to us by going to estatemeeting.com. You go there, you pick a time, we'll meet you over the phone, we'll talk to you about whatever you want, estatemeeting.com. Okay, so today, by the way, if you are listening to this, you are missing out because I'm wearing a suit. It's been a long time since I wore a suit, but we did some will signings for some clients today, and so I suited up, and I feel great. If you're watching some video, hopefully I look as good as I feel. But we're not here to talk about me. We are here to talk about making handwritten changes to wills, which happens often. So I get this question all the time. Actually, I've never talked about it before, I don't think, but it's something that's important because it can have some unintended consequences for those of you that are trying to change your wills by just writing on them. And here's the deal. There are 3 requirements for a valid will or a valid codicil, which is a change to a will, to occur. Number 1, it needs to be signed by the person. It has to be signed. Number 2, it needs to be done so in the presence of witnesses who can attest that the person has the capacity to sign and is not signing under duress. Okay, if you can get those things in there, then you have a valid will. Often those things are not present because you don't have the witnesses around when you're making these changes. You just handwrite them in. You don't re-sign, and so those things can get in the way. Okay, so that's the very, very short answer to this problem. If you want to make changes to your will, I would highly encourage you to hire an attorney, first of all, just to make sure you're doing it right. It's one of those things that occur frequently in estate planning where if you think you're doing something right, you're not sure until it's done, and it cannot be undone. What that means is, you do the codicil, then you die, and your family shows up. They can see what changes that you wanted to make, but were not done correctly. They're not done validly. And because they're not done validly, there's no way to ensure that you did them and that you actually wanted them to be done. And that's why these requirements are in place. So in that case, then it goes back to the old way. And that, again, can have unintended consequences for you. It won't be what you want. So if you are thinking about making changes to your will, please, please, please do not go and just start crossing stuff out in your will. Do it the right way. Create a codicil. You put the codicil right on top of your will, and they both travel together so that you can see what the original will looked like, what the changes are that you wanted, and you can see that the changes have been executed and created in the same way that the original will was. Okay, that is it. Hopefully you like that. If you did, hit the like button. If you know someone needs to hear this, please share it with them. If you have questions or comments, please leave them. And if you want to talk estate planning or probate and you want to do it for free, you can go to estatemeeting.com, set up a time to talk with us. I would love to chat with you. Estatemeeting.com. All right, that is it. I'm Christopher Small. I'm the owner of CMS Law Firm. We do estate planning. We do probate. We do it well. Thank you for your time. Thank you for your attention. I appreciate you, and I will talk to you again tomorrow. See ya.